So I'm Bobby Fazy, president of Insight Law. I'm an estate planning attorney. Today we're going to be talking about estate planning. I know there are some questions about special needs trust as well. We'll make sure that we address that as a concern. And so let me go ahead and share my screen. There is I think the main thing that I want people to get out of this program is education on their options. I'm very education based. I want to make sure that people understand. There's a lot of noise out there in the estate planning world. And so one of the handouts that you were given was a sheet that says selecting and working with an estate planning attorney. These are the questions I would be asking an estate planning attorney, knowing what I know now. And so everyone asks about price, and that's a good question. We'll talk about fees and different options. But there's about 14 other questions you should be asking your attorney. And then hopefully today, you'll have an idea of what the questions are. Well, you'll have those questions, and you'll at least know how we answer those questions so you can do your own due diligence with regard to that. And again, so that's me. I'm the lead attorney here at Insight Law. We have a core team of 10, and then we've got some other kind of attorneys that are of counsel in different jurisdictions and the like in different practice areas. You're going to find that if we work together, I'm a very blunt attorney. Most estate plans just don't work. How would you know if your plan worked or not? Maybe when would you know might be a better question to ask, is maybe it's after you're gone, maybe it's too late. My goal today is to make sure you understand where your planning stands at this point, and if you need to address any of those issues. I'm a visual learner, and so I have my clients basically do the snapshot test. And the snapshot test is pretty simple. It just means that you want to visualize the time after you passed away. You're looking down from your cloud up from above. All my clients look down, they don't look up, right? Beats the alternative. If money's going where you thought it'd be going and doing what you thought it'd be doing, then that's generally a plan that worked. Money's not going where you thought it'd be going and people not doing what you thought they'd be doing, probably a plan that didn't work. And so the goal today is, you may have a snapshot in your head. I'm hoping to get that picture a little bit more focused because I'll show you what your options are with regard to that. A lot of people focus on the documents. I think those are traps. Like they focus on, what document do I need? Do I need a power of attorney, a will, a trust, special needs trust, right? The documents are important. They're the tools. But the way my analogy with regard to the documents is really, I watched a show called The Fixer Uppers. If you've ever seen it, it's basically a couple that goes to people's houses and they renovate people's houses that want the work done. Joanna is the one that sits down with the clients and says, how do you want the kitchen to look and feel, get their goals, their vision of the house and how they want it to be remodeled. And Chip is the carpenter that comes in with his tools, right? And so my analogy with that on the legal, on the estate planning attorney side is, does anybody ask Chip or the carpenter when you're doing a renovation what tools they are using? Probably not, right? And so the same thing with attorneys. Our documents are our tools. And the most blunt thing I can say to you is, when something happens, when you die, the documents aren't going to jump off the shelf and do the work. Okay, it's people, it's usually your family. And so we want to make sure that that's a smooth transition at that time. And so, yes, documents are important. We'll make sure you've got them, but don't just focus on the document side of things. A lot of other people focus on taxes. Okay, of course, taxes are important, but that's not the only reason to do planning. Okay, and so, hey, I don't have a taxable estate. I don't have a big estate, so there's no need to do planning. That's short-sighted as well, because there's a lot of other issues that we'll show you today that are just beside the taxes. Obviously, taxes is important, and we want to make sure that we've got that addressed. And also, taxes with regard to special needs trusts are important when it comes to IRA planning. And there's certain laws that have come out, the Secure Act, that addresses that, and that's fairly recent, that you didn't be aware of. And then the transfer trap. I just want to avoid probate, right? And if you don't know what probate is basically the court or government supervised audit of your estate after you die. And it is completely avoidable, okay? But that, again, that's not the only reason to do the planning. It is one of the important ones, because I don't like to be on the court schedule. But we'll show you some techniques that we use to address that as well. What I find is that people really don't know all their options, right? And so a lot of times people are just getting some word process documents, giving you some biographical data, and they're not being counseled on their their options, what they have. And so your snapshot that you may have might look fuzzy because you don't know all the options that you have, and you can't make an informed decision. So I always start with the basics when it comes to estate planning. And so the main thing, one of the basic things I want you to take home from today, if you don't remember anything else, is the definition of estate planning. This is not like Webster's dictionary definition or Black's Law Dictionary. It's the National Network of Estate Planning Attorneys definition. I like it. I'm an instructor there. I think it covers all the issues, okay? So the first part of the definition is, and I would ask the attorney that you're working with, how do they define estate planning? And the way we define it is, I'm going to control my property while I'm alive and well, right? So if you're healthy, alive and well, things really shouldn't change too much. A plan for me and my loved ones if I become disabled, mental disabilities, right? You can't manage your finances. What's the plan at that time? And then give what I have to whom I want, when I want, in the way that I want. And I find a lot of people don't know the different ways they can leave their assets to their loved ones, and we'll go through that. All while assuring my wisdom is transferred along with the rest of my wealth. So I try to set the bar high. If there's some non-material wealth, values, life lessons that we can pass on, let's try to bring that along as well. This planning pyramid is how we work with clients. Every family is different, but this pyramid keeps things consistent as far as making sure we've got the issues covered. With the most important issues being towards the base of the pyramid and then working our way up. So the first part, I want to know, first part of our planning process is, who are you? What are your goals? What are your concerns, hope, fears, and concerns? Then we're going to get on to the family side of things. Are you married or are you single? Are you divorced? Are you widowed? How are they with finances? How is their health and the like? Are they working? Are they retired? Then we look at the beneficiaries. If you have kids, how are the kids? Are they minors or are they adults? Whole host of different issues for minors than we do for adults. How are they with money? How do they get along with one another? If there's a health issue or a special needs issue, how does that look like? And what do we need to be concerned about with regard to those issues? Okay. If they're married, how are their marriages? Strong, shaky? So once I know the lay of the land, then we can present options to preserve wealth, expand wealth, save taxes. But just going ahead and giving you strategies without knowing your situation is not a good approach. And I find that the attorneys who are just saying, here, we'll sell you a trust for $29.95 and not even knowing who you are, that's got a concern for me, because there's not something there that, how do they know what's right for you? So the idea is you teach me the family, and we'll teach you the law, and together we'll make the plan work, okay? And this other slide is another important slide if you are taking notes. Every plan, I get asked to review people's estate plans, or every plan, any plan that I've seen that works and ones that we do that work, right? There's 4 keys that I find consistently in each of those plans. So if you can check these 4 off, you're going to be in good shape, okay? As number 1, did this person get good personalized counseling as opposed to word processing? And yes, I spelled counseling with 2 L's. I'm trying to make a point that there's something more to offer from the attorney than just spitting out some forms, okay? So we want to make sure that we have that covered. And so there's some counseling issues that I'll show you that are addressed in a couple of slides down. And then the second big pitfall that I see in estate planning, a very common one, is making sure that you have proper asset ownership. And the pitfall is people usually have their assets improperly titled. There's only 3 ways you can own your assets, okay? In your individual name, jointly, and by contract, okay? And the last one kind of confuses people, the contract one. Contracts are things like your IRA, TSPs, life insurance, 401ks, trusts are contracts. Payable on death designations from the banks are contract. So every one of those contracts have a different type of way of interpreting and impact on your plan. And so I find that people have these instructions set up, but their assets aren't titled the right way. where if they're improperly titled, the instructions won't actually apply. They're gone. Okay, and so we're going to make sure that you understand that impact on your planning. And then let's have an agreement. How often has this plan been reviewed? When was the last time this plan was updated? Okay. The Congress keeps me busy. There's a whole slew of legislation that's being, it's in proposed mode right now. That's probably going to pass before the end of the year. That's going to impact everyone's retirement plans. It's called the Secure Act 2.0. Okay. And so we want to make sure that we're comfortable with that because a lot of our clients have a lot of their money in retirement plans. And so how can you have a plan that was done 10 years ago that would actually work today if there's laws that were never even in existence, right? So that to me is a very important point, is that you have some type of updating process. And I think really you wouldn't be listening to me today if you didn't care about having some type of controlled transfer process. So again, I'll get blunt. If you were to die today, how prepared is your family if something happens to you today? Right? I mean, we have to draw the line somewhere. Why not do it today? And so my question is, would they have any idea what to do, how to do it, and how to pay for it, right? And so typically what happens, the death occurs, the family stumbles into the attorney's office at that point, they're grieving. They have no idea what the plan says or how it works. They're one-on-one with the attorney. The attorney's charging hourly and they're grieving, nothing's sinking in. And the process takes long and is drawn out and it doesn't really, it's very expensive. And people are like, why doesn't it work? Because the process, the typical process doesn't make any sense. I can poke holes in it all day. And so I want to show you your options that are out there. There's 5 major ways that I see that you can plan your estate out there. You can do no documents. I do not recommend that approach. That's we'll talk about the pitfalls there. You can do a will and a POA. A POA, you're going to live, estate planners, we live in this world of acronyms. I'm sorry, but I want to get you comfortable with that lingo. A POA is a power of attorney. There's a couple different flavors of powers of attorneys. There's financial powers of attorneys. There's healthcare powers of attorneys. Okay, as the name suggests, the financial powers of attorneys are where you designate an agent to make financial decisions for you. And there's 2 flavors of financial powers of attorneys. There's a general durable power of attorney, which is effective when you sign it. And then there's what's called a limited and miscellaneous power of attorney. Sometimes people call it a springing power of attorney that springs into legal existence after you've been determined to be disabled. Do you see the difference? General durable, effective right now, which means if it gets into the wrong person's hands, they can do whatever they want, versus one that's only triggered after you're disabled. Which one's right for you depends on your situation, okay? The healthcare power of attorney deals with healthcare decisions when you can't make the decisions yourself. And everyone starts jumping right to the living will component. And there's a living will component to your healthcare directive, which says, I call it the pull the plug document. But that's not where we want to go to right off the bat. Okay, that's like I'm hoping that's the last thing, but let's not just jump to that point right away. So that's a simple will and power of attorney approach, and my engineers love formulas. And so if if the will is kind of the centerpiece of your plan, then the will equals probate. And so that's driving the family to probate. Whether that's good or not for you just depends on the situation. You can do typically none of my clients will want to go through probate, and we haven't had to go through probate, except one that broke my perfect probate record, which I was very upset, but they didn't disclose an asset. So it wasn't on us. There is a will with a testamentary trust and power of attorney. So stay with me. A testamentary trust is one that's created last will and testament. It's created after death. Okay. I typically don't like those types of approaches unless we have to go that route, because there's court oversight on that. And the less court involvement in my mind, the better. And so that's building in a trust to your will. You can do a simple trust. I kind of put that in the word simple trust, and that it's very boilerplate. There's basically the attorney got biographical data and spit out some forms. Not much to that beyond the documents. And then we follow the modern approach. The documents are just part of the deal. It's really the process that is the key. Okay, when someone becomes disabled or dies, what happens, who's doing what, the documents are supporting that, those are the tools that are supporting the plan, but we're getting your family to the place they need to be as smoothly as possible. Okay, forget about getting mired in the documents. Okay, yes, we're going to make sure the documents are right, but that's not the only thing to be focused on. Okay, I think any of those things in the middle are pretty much bare bones planning. The one on the left has no planning at all. And so you pick your poison, which one you like to do. And I see a lot of people, are in these four categories here. Our clients are over here, and I think that's where we want to be, and that's the kind of practice that I want because of the challenges that are out there. Okay, so major challenges in the estate planning world. Number one is mental disability. Okay, not only mental disability for our clients, but for their beneficiaries, their kids as well. We have to look at that. For our clients, that's a big issue. And to be blunt again, if you're disabled, it's a lot more difficult to administer your plan than if you're dead. Sorry, because if you're dead, we don't. When you're disabled, you're here, right? We have to figure out what we're doing with you, what kind of care you're getting, where you're going to be. Where's the money coming from? How's that money going to be used? And what are your preferences, right? A whole host of issues that I don't have to deal with on the administration if you've passed away. And so that's a big deal. And then also for your beneficiaries, if we have issues there, then we have to think about special needs side of the equation. So I'll talk about some of the issues with the special needs point on that. Asset transfer on death is another challenge. We'll talk about that. Taxation, and then personal planning goals. So these are the main challenges: disability, making sure that assets transfer to one place to another as smoothly as possible, make sure we minimize taxes to the greatest extent, right? And achieve the goals that you're trying to achieve. Our approach to that, so is the modern approach, I think, is the way we do it, is it's a three-step approach. We want to empower your design. What that means is we want to develop your plan with counseling-oriented planning partners. So estate planning, I don't think should be done in a vacuum. So if you have a financial advisor, let's make sure we're on the same page with them. If you have a tax advisor that is a trusted advisor as well, let's complement the plan with them. And let's give you some good counseling options. I'll narrow down the options, but ultimately you're going to make those decisions. And then empower your legacies by really just making sure that the plan is updated. So we want to make sure that we have some type of commitment to updating the plan for you and yourself. And so making sure that we have some type of continuous updating program, because the laws continue to change. Your family changes too, right? And there's different techniques out there that change over time, so that the inheritance can be empowered. What does that mean? That we can secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So it's a three-step approach where we're beginning with the end in mind. We're expecting to do the administration. We've done over 50 administrations, okay? And so we know what we're doing on that end. And it's not about our approach where we want to get you in and out as quickly as possible and then go find the next client, okay, and not worry about what's happening down the line. We'll worry about it later. We're going to set the plan up, do the follow-up, make it custom, and then make sure we maintain the plan so that when something happens, it's as smooth as possible. Different approaches there, okay? All right, so let me give you some quick items on the transfer issue. So a lot of people focus on I want to just avoid probate. And so I told you, basically, probate is a government audit of your affairs. And again, our engineer clients love formulas. And if anything that's in your individual name when you die equals a will, equals a probate. Those things are going to go through probate. All right, so how do I avoid that? You can avoid probate without doing any legal documents at all, if that's your only goal. I'll show you. So you can title everything as joint tenancy with right of survivorship. The way that works is the way you can legally title, your assets, like a joint bank account. So you might be familiar with that. When one joint tenant dies, the asset will, by operation of law, automatically go to the surviving joint tenant. All you do is bring the death certificate down to the bank or the investment company. They'll go outright into your own name. Okay, so you've avoided probate on the first death. Let's say we're in a married couple situation. First spouse passes away, leaves everything to the surviving spouse. What happens on the second death, right? So now you're telling me when the second surviving spouse is in the grieving process, they got to figure out how everything works and how they want to plan their estate, because it's going to go through probate at that time. Why not just do it right the first time up front and just get it over with, rather than kick the can down the road and have issues at the wrong time? Okay. And then also, if you just add people to your account, I'll just add someone else, you're adding all of their creditors, all of their liabilities, and they own the account with you. So that could be something that's dangerous as well. You can do a transfer on death account. Those are the bank's forms. I'm not a big fan of those forms, and it'll just say the asset goes outright to these people. I'll show you that maybe we don't want the assets to go outright directly to those people. And then planning with the box is, with my put those in quotes, are those beneficiary designation forms. So if you have an IRA or 401k, there's a beneficiary designation. If you list the right people there, then those will avoid probate too. But there's a lot of tax implications, at least on the qualified or IRA plan. So you better make sure you get that right. So you need to have some counseling done with those issues. Okay, so what are some planning, what are some counseling issues that we go through with our clients? What do we go through on a regular basis? So number one is catastrophic illness protection, disability planning. I already mentioned that. Remarriage protection, creditor protection, divorce protection, values promotion. So we'll knock out those, and I'll spend a little time on the catastrophic or the disability planning. So I know we've got some special needs, potential special needs issues. So the one thing with the disability planning first for our clients is we want to make sure that if they have that big illness towards the end of their life, stroke, Alzheimer's and the like, do they have an opinion if they want to stay at home or go into a nursing home, or they don't care, right? And if you do have an opinion, where in your legal documents does it say what you want to do? Typically what people get is what's called a healthcare power of attorney or an advanced medical directive, which designates a healthcare agent to make decisions for you when you can't communicate to the doctor. And it says, the healthcare agent, you can check me into the hospital, you can check me into the nursing home, you can keep me at home and bring home care in, you decide, right? And so I'm saying, if it's that important, why don't we put it somewhere? And if you don't care, you're not doing your family any favors by doing that. That's a huge burden on your family. My dad had a disease called Lewy body disease that caused dementia. And he loved us, but we never had that conversation with him. And I'm thinking the first few years, okay, at home is all right. My mom, we can handle it. Years 7, 8, and 9, he was basically not there at all. And it was round the clock care. And I don't think he wanted to burden my mom with that, but we never had that conversation. Okay. And so the estate planning attorney should facilitate those issues and make sure that we address them on that side. Now, if you have special needs beneficiaries that you're concerned about, that's something to also think about. There's some things that you need to address. I'll throw in my other slides here with regard to the special needs side of things. And so the main thing there is you have to understand there's a special type of trust called supplemental needs trust or special needs trust. And so, what is special needs planning? It's estate and financial planning, right? Designed to provide and protect for a beneficiary with special needs, because there's certain other issues that we have to worry about. There's government entitlement, there's entitlement programs, okay? A lot of them are needs-based, okay? And so we want to make sure, and you can't get into these programs, unless you qualify and fit into these certain boxes, right? And so there's 5 unique challenges when we find special needs planning. Number one is providing for loved ones without jeopardizing benefits, right? We don't want to jeopardize any benefits. We want to supplement the benefits, right? We want to enhance the life. And also, if we have kids that are healthy and kids that are special needs, how do we treat everyone fairly, right, and equally? And then where's the money coming from? Okay, do we have sufficient funds to kind of provide that liquidity? And then who's the right person, right? The trustee, to give you some terminology, when we have a trust is basically a contract, okay? And if the trust is done right, we're basically stacking the card deck in your favor, right? But there's 3 parties to the contract initially, okay, for a trust. The trust maker, that's typically our clients, the person making the trust. The trustee, usually our clients too, they're the ones managing it initially. And then there's the initial beneficiaries, right? So who's the people going to be benefiting from that trust? So, maybe you've got the game plan all laid out, but what about your backups, right? Do they have the game plan, and are they the right people? Then what we find is that there's longer life expectancies for our special needs beneficiaries. Healthcare is just getting better, medical techniques are getting better, and so it's all about quality of life. And so we want to make sure that we're not, creating any resentment or anything along those lines. So every family is different, so we have to look at the family situation. What is the family's personal resources? And so we want to make sure how those look like, and there's no guarantee that public resources will exist or cover, the beneficiary's issue. So we want to have some way to supplement those. And then also they could be taken advantage of. The beneficiaries could be taken advantage of depending on where they are mentally. And so they might be poor judgment, or they might be exploited by somebody. So we want to just make sure that we are protecting them in the best way possible. A couple ground rules is that when the beneficiaries up to the age of 18, you're basically under the parents' care, and you're not eligible because all of the parents' resources are going to be attributed to the minor beneficiary. But on age 18 and beyond, then the legal authority for the parent ends, and so then the deeming of the resources is no longer applicable. Now they can, if they have their assets titled in the right way, right? That word, the word that we use from estate planning attorneys, and I know it's terrible, is we call it funding. And everyone's like, what is funding, Bobby? And so funding is just about titling your assets in the right buckets, okay? Titling in this trust versus this trust. And so that is important, and we want to make sure those things, because a lot of these government benefits depend on how those assets are organized for the beneficiary. Okay, it's a puzzle, right? When it comes to benefits, it can be very confusing. And so you just need to know how it all works. You got something called supplemental security income, that's SSI, versus Social Security disability and insurance. Okay, and so I'll tell you the difference. Then you've got Medicaid that's connected to supplemental security income. If you got $1, if you're qualifying for $1 of supplement SSI, you get Medicaid, okay, which is usually where we want to be when we have a lot of these government programs within there. And then you've got Medicare, and there's always a lot of people get confused between Medicare and Medicaid, okay? And so the public programs, the ones that are needs-based, okay, that's ones where the financial resources of the individual matter. That's the SSI one, okay? SSI is needs-based, and that's Medicaid is needs-based, okay? And a lot of those programs are there. Not needs-based is SSDI, Social Security Disability Insurance. So you can be Bill Gates, okay, and you can still get Social Security Disability. It really depends on your work record, maybe the parents' work record, when you were disabled, okay? And so those are things, and SSDI is associated with Medicare. SSI, Medicaid, SSDI, Medicare, all right? So we want to make sure that we can look at those and make sure that we're in the right program. These are the old numbers. I haven't updated these numbers, but the idea is SSI provides some type of supplemental security income to the beneficiary. That's not usually what the big deal is for them. What we really want is we want to make sure that we have at least $1 of SSI being generated, and they can get disqualified by making too much money or having too many resources. And if you have $1 of SSI, then you can get onto Medicaid, okay? And what is Medicaid? Is an economic needs-based program. It's not health insurance, and so it's funded, but it's administered by the states, funded through the federal government. Federal government sets the overall guidelines, but each state has their own special rules with regard to it. And like I said before, that's the key thing, is that $1 of SSI triggers it. So a lot of times our planning is we want to make sure they have at least $1 of SSI if that's the way we want to go, and that we're protecting that. And that covers medical services, and there are definite income and resource limits, and you have to be basically penniless to get onto it. If you are a veteran or a spouse of a veteran that was serving in active duty, There are veterans benefit during a time of war. There's veterans benefits that are potentially available to you as well. SSDI is associated with Medicare, and that's based off of your work record often. And so you need 40 quarters of work. And then also the disabled adult child is available when the eligible person gets Social Security, then the child can get SSDI. So sometimes we'll get the child qualified that way. And it's triggered after 24 months of SSDI payments. After you get 2 years of SSDI payments, then you're on Medicare. Okay, so common planning strategies used for special needs individuals. Do nothing. I don't like that one. Guardianship of the person and the estate is where you actually go and get guardianship over them. You file a guardianship proceeding over and to get control over the healthcare decisions and a conservatorship proceeding for the assets. Powers of attorney, having a power of attorney to manage the financial assets if they are able to do that. Disinheriting them, I don't like that approach. That's a poor man's way of making sure that they get benefits, is don't leave anything to them. You can do gift to a third party saying, hey, you have a moral obligation to take care of them. Too many different things that can go wrong with that. Joint ownership usually blows benefits if they do that. Outright gifts, not the way to be doing that as well. And then the way that we're going to be talking about, obviously, is trusts. There's two types of trust. There's a first party trust, which is a self-settled trust, which means it's the disabled beneficiary creating that trust, or basically it's from their resources, versus a third party trust, which is very common, where the parents or some other relative is basically funding this or setting up this trust for that special needs person. And so really the special needs trust is the planning tool of choice, because all the other stuff is very uncertain. You have no idea where the cards will fall on that. And so it can be anybody that creates it. Okay, it doesn't have to be related. It's usually a parent that funds it, and you create it on behalf of that individual. There's two types of special needs trust that you should be aware of. One is a standby special needs trust, and the other is a standalone. The standby special needs trust is created after the parent dies, usually, or after that person who created the trust dies. So they've got this trust set up, but that special needs trust for that individual does not get formed or created until after they pass away. There's some benefits for those. Those are usually cheaper because you can build them into your own plan. But I'm not a big fan of those when we're dealing with individuals, special needs individuals, because I like a standalone special needs trust, which is created right now, right when we sign it today. That way we can fund it today if we want to. People can leave assets to it. Can't leave assets to a standby trust until the death actually occurs, okay? Standalone, you can fund it today. You can also get your trustees trained and in the place so that they know what they're doing, or your backups, and ready. So you kind of get the plan all set up, ready to go. And so I think that is a good one. That's the way that we typically will do it for the clients. Okay. And then it's not always needed. A special needs trust is not always needed for disabled person, but we just need to look at the whole picture. But typically, once those assets go into that special needs trust, they're not countable resources for, and that won't jeopardize benefits. And it's a pool of funds to be able to supplement. They just need to know the rules of the game on how they can supplement, right? And that's very, that's where the attorney should be able to lay that out for people. Okay. And then can also achieve greater independence by maximizing private and public resources. So just depending on where the beneficiary is and kind of how sophisticated they are, we can provide maximum independence if that is a goal. Here are the advantages of special needs trust. I basically bullet pointed them before. Funds in a special needs trust don't count as a beneficiary's resources. provides continuing management when family is no longer available, right? So we want to have continuity is really critical, I find, with our beneficiaries there. We want to keep things kind of going the same. And so we don't want a big disruption on the major life events. Independence as much as possible, and so that's important. That's the main things on the special needs side. And I know I didn't put those in the slides that were given. So if you want those, I'd be happy to, provide them. But that to me, it's really, as long as with trust planning, it provides that flexibility. It provides you, I think that's the preferred method to go with any type of planning. And so a lot of people are making the decision, hey, do I just want to create my own revocable trust and have a standby trust after death, or do I want to have my own revocable trust and have a standalone one right now? And so it depends on your situations, and that comes in when we think about your specific goals are, and where you're at. Okay, so that is enough of the catastrophic illness planning. I know I'm a downer. Let's go into remarriage protection. Here's even more. Here's the remarriage protection is more about the side of if you pass away and then your spouse gets remarried after you pass away, making sure that those assets that you've left to your spouse go to your intended beneficiaries and not any new spouses that are out there. A lot of people say, oh, we'll never get remarried. You never know. I'm finding out with things happen in these retirement communities. So this remarriage protection is one issue to be aware of. And with trusts, there's a good way that you can protect, leave your assets to your loved ones. They can use it for what they want, but when they pass away, it has to go down to your intended beneficiaries. Creditor protection, a lot of people are interested in this one, and there's a lot of misunderstanding when it comes to creditor protection and trust. So I use my school bus story to explain how all that works. So the school bus story goes like this. There's two assumptions in the school bus story. I'm dead in the story, and there's no creditor protection for me while I'm alive. So let's say I've died, and let's say my spouse is driving down the road, is all grieving from my death, distraught, not paying attention, runs a red light, bam, hits a school bus full of kids. Let's say there's horrible facts. Let's say one of the kids dies. My wife hates herself. The world's against her. There's not enough money in my estate to pay for hurt and killed school children, right? These are catastrophic creditors. One of my clients said, Bobby, you should make it a school bus full of lawyers. That way you'll have some better sympathy from from the clients. But the idea would be that with regard to that asset, so there's some type of judgment that my beneficiaries are liable for. Okay, and now there's a couple different ways I could have left my assets to them. Okay, there's different legal impacts. I'll go through each one. The first way I could have done is I could have done a simple will, and I could say I'm leaving everything to my spouse. It could be my other loved ones. I'm just using the spouse in this situation. I leave everything outright to the spouse in a simple will. They hit the school bus. There's a judgment against them. Everything I left to them is gone. That's fair game for the creditors. That's gone. The second way I could have done my planning is I could have done no documents, and I could have just titled everything jointly, right? Remember that thing called jointly with right of survivorship? I avoided probate, but everything is going outright in their name. So let's say the house, right, that was jointly owned when I was alive, I'm dead, now it's just outright in the spouse's name. The creditor can put the lien on the house and foreclose on it, okay? Or they could take the bank account, take a garnishment on the bank account. Anything that was jointly held is fair game, okay? The third way is by contract. Let's say I had a life insurance policy, okay? Not worth a lot when I'm alive, but let's say it turns into $1 million when I die, and I wrote the spouse's name on there. Spouses gets that $1 million, they put it into their bank account, they hit the school bus, gone, okay? Let's say they did one of those simple trusts that are very bare bones. It says when I die, everything goes outright to them. Same problem, that money is gone. So what if I did my planning again, right? Let me pull myself out of the grave, do my planning again. What if I did it this way? I could leave my assets to whoever I want. They can use it for whatever they want. But if they hit the school bus, it's protected from their later creditors. Let me say that one again. They can use the assets for what they want, but if they hit the school bus, protected from their later creditors. So my goal is that you really are connecting the dots. If you remember that definition of estate planning, I'm going to give what I have to whom I want, when I want, in the way that I want. My question to you is, how many of you would like to leave your assets to your loved ones that way, protected from their later creditors, right? And have you ever been asked that question before? Okay. Is that counseling? Is that word processing? Right. And so my goal is get with a counseling oriented attorney that can show you those options. Whether you want that or not, that's up to you, but we can narrow them down. And the way that you can do that is through trust law. I have a little visual here. So my little trust box, I have a little box that represents my trust. So think of a revocable trust as like an open box, and you can put all of your assets in it. From a creditor protection standpoint, a revocable living trust, revocable kind of confuses people. You can change it, okay? You can amend it and change it at any time, right? And that's a very common planning technique to be used. So, but there's no creditor protection. If you heard that story, there's no creditor protection for me when I create the trust, because I can get in, my creditors can. But when you pass away, you can put the lid over it. You can say, here's my hard-earned wealth for my beneficiaries. My money is to be used for them, not for their ex-spouses, not for their creditors, not for Medicaid to spend down, right? So with their money, you can do whatever you want. This is my money that I'm laying out the rules for. Big difference, okay? You can do that with trust law. And so that's something to consider when it comes to the planning that you have there. Divorce protection, I don't spend too much time on that. It's just, how would you like to assure that the asset that you leave to the beneficiaries stays with them, right? And doesn't go with the new outlaw that's out there. A lot of clients like that. Yep, I want the bloodline protection. That's fine. And then values promotion. This one is more about, I call my babysitter story. So I have a 6-year-old. I got started late in life. And I don't know, the first time we were hiring our first babysitter, we were trying to go out for a nice relaxing evening for a dinner and a show, right? And one spouse is saying, okay, she's going to want to stay up late. If you read a book, read every page, because if you skip a page, she knows. I don't know how she knows, right? She's not going to want to brush her teeth. We're going to be here. Here's our phone number, our neighbor information here. You get the idea. We're leaving a lot of instructions that we're just going away for one evening, right? So my point is simple. Would you agree that we leave more instructions for our loved ones when they're little and we're going away for just one evening for a dinner and a show than we even think about leaving in our estate plans when we're going away for a lifetime, right? And so there's places, right, where we can do that. And our job is we have a certain checklist that can identify, record, and memorialize those values if that is something that we see that's a good need. And the way the planning process I think should work is, I call it like kind of the trip to the eye doctor. There's a lot of different options. We're going to narrow them down, right? Which one do you like better, one or two? I could never guess when I go to the eye doctor, but you get the idea, is that we're going to co-create the plan together, okay? So that's our setup. Develop the plan with counseling-oriented planning partners. I was trying to give you a flavor on how that looks like, okay? The second is, okay, now that we've got it all set up right, let's maintain it. Let's make sure it's maintained with changes in your life and the beneficiaries' lives, changes in the laws, and then changes in the different strategies and techniques that are out there. Early on in my career, I used to focus on, hey, things are going to change. I think people get that. They just don't want to pay the attorney to maintain it. I was like, okay, focus on the fees. Don't focus on why you had to maintain it. So let me explain why and what we're doing. And we try to keep things reasonable for the maintenance, because we want to make sure that the vitals are being checked routinely, not to be overkill, but making sure things are so that when something happens, we're in good shape. So we have a maintenance plan. It's an optional, we're not going to force anybody to do anything. We charge $975 a year. Okay, that's it for the whole year. What do you get for that? We're not going to nickel and dime you for phone calls, emails, faxes, and letters. You got a question, call us, okay? The way we do it, and our phone is not ringing off the hook, is we do schedule phone appointments, a certain time that I block off during the week, and we go ahead and schedule the phone appointments there. Obviously, if it's an emergency, you're going to get bumped up the queue, right? Copies, word processing amendments, someone moves, name changes, those types of things. That's part of the deal. I'm not going to nickel and dime you, all right? The annual funding double check and ongoing funding support is worth the fee right there. And you're like, what the heck is that? right? So the annual funding double check, and you need to understand this because that's important. The annual funding double check is talking about if you have a trust, and you should have a trust typically, and it's about titling the assets in the trust. So I put my box back there. So think of this cup as your trust. Funding is making sure the assets are titled properly in the trust. And pretty much we want everything we possibly can in the trust with some major exceptions like retirement plans. I'm not going to get into all those weeds right now. And so the reason why you want everything titled right in the trust is that if one asset is left out, guess what? It's not controlled by the trust at death. It will eventually get controlled by the trust. We got to go to the probate court, and then the probate court, we have to go through that administration, and then it gets into the trust. So little legal technical for you, a lot of very common estate plan for people is that they'll create a revocable trust, kind of your contract that lays out everything. And the trust is really like your will. Okay, it's a will it's the preferred way. The will, you'll have a will, it's called a pour over will. It's a backup. The will says the will's only beneficiary is the trust. It says if I forgot to put something in the trust, put it in my trust after death. So it'll eventually get there. The bad news is we're taking a stop at the courthouse before we get there. Okay, and so, and only in very rare instances do we actually want to go through that technique. Okay, but oftentimes I don't, and I usually just record the will. I don't want to even have anything going on with regard to the will because I don't want to deal with that court administration. So the annual funding double check is every year we'll upload your asset review report to this portal, right? To your portal, and this will say, hey, this is what we've got for you as a list of your assets. Let me make sure I'm sharing this screen. Sometimes it doesn't share. And you give us the new values. And if you sold something, you cross it out. If you bought something new, add it on there. So I don't have to play Sherlock Holmes to go find everything if something happens to you. It cuts a tremendous amount of time and expense off of the administration. Big, big, big report that we have. In year one only, we'll do a family meeting at no additional charge. So we'll huddle a family up, and it's optional. I'm thinking about requiring, but every family is different. And we'll go over the plan as high level or as detailed as you want with whoever you want, so that they know the game plan when we need to know, when they need to implement, right? We have an annual client meeting. We do this in group format to keep these costs down. So the annual client meetings are usually in January and February. I'm going over, and been doing it through Zoom since the pandemic. I used to do them live. Basically, I'm going over what's going on with the laws. The big laws that are going to be in flux right now are those Secure Act laws. They're dealing with IRAs. There's other tax laws and things that are going to be out there. And so we want to make sure that our clients know what's going on with the laws, right? And so this is what's going on with the laws. I tell them also what's going on with the law firm. We keep growing, which is a good thing. And then the different techniques that are out there. And so that's the annual group client meeting. Every 3 years, we're actually update your legal documents, okay? We do those in group document updates. We've been doing this for 15 years, okay? So the first few years, we're still figuring out. We have a very strong system where we're able to get you the education on the legal updates, and we have a report that we use that you fill out and complete before the meeting, which is basically an executive summary of your plan that says, here's your key provisions. Are there any changes? Okay, yes or no. And you tell us any personal changes. It's a great way for you to communicate any personal changes to us. And then any of the legal changes we'll put in. And so we're able to do that on an efficient basis as well. And then we have group educational programs on different issues. The one that's most attended every year, the Saturday before Thanksgiving, I call it nuts and bolts one. It's, some people call it the 911 program. Right? What to do when a loved one dies or becomes disabled. What's like the first 3 or 4 things you need to know and where things are at, right? What's the checklist and the break the glass information. But there's other types of programs, maybe on the Secure Act or maybe on the special needs developments, right? So those are things that we're doing because education is important to me. And then DocuBank membership is dealing with your medical directives, right? So remember your healthcare power of attorney, your advanced medical directive is a legal document designating your healthcare agent to make decisions for you when you can't communicate them to the doctor. If you get into an accident, right, and go to the hospital, you're probably not carrying your medical directives in your back pocket, right? And everyone's like scrambling for those things. And so part of our services, our clients are able to get to our portal, but there's a DocuBank portal that basically you'll get a little credit card. I didn't bring my wallet in here, that stores your medical directives. I tell you, sandwich that card between your driver's license and your health insurance card, and when you get into the hospital, they're going to want to know, number one, who you are, so they look at your license, and then number two, if you can pay. And then that card's right between them saying, my directives are here. There's an 800 number on the back. There's a website. So it can be pulled down and someone can call, and it can be faxed or emailed 24 hours a day, 365 days a year. The card looks like this. Nothing fancy, but it does the job, right? And literally, like, I don't know how long I've been doing it, 30 seconds, I've got my medical directives printed out, okay, or they're up to be ready to be printed. And so I'll show you, I wanted to show you some of the features, but there's my medical directive. But some of the features of this card also, you can have medication lists. All right, so medication lists, because when my dad was sick, he was on several different ones. Having everything in one place, the dosages and the frequency was nice. Or the medical snapshot, the history, the family history, the doctors. And for special needs individuals, there's a special card they have for that, for their medications, their family history. So that's a nice thing to have right there, able to be accessed at any time, okay? And then also you're notified, emergency contacts are notified when that card is used, which is awesome, okay? That's all part of this maintenance plan, okay? So we try to pack in a lot of value, and the way we do that is we have really strong systems and processes. If you need more, that's fine, but I just want to have a core set of things that we're touching on that are covered by that maintenance plan. So that to me is one of our big distinguishing factors from us and a lot of other firms, is that we stay with our clients. It's very important to me to do that. And this is kind of a summary of our maintenance plan, is that, yes, the asset review report, important, we know where the assets are. Estate planning review worksheet, we know your instructions are updated. We got the annual client meeting, boom, education. We're updating the documents consistently on a 3-year basis, and then the family education and training, okay? All right, so we set the plan up, we've maintained it. Now the third step, right, securing appropriate assistance to transfer your wisdom along with the rest of your wealth. So now the time has come, you pass away, does this plan work, right? And so without what we think is, I don't know about appropriate assistance sounds like to you. For our clients and for me, it sounds like, okay, let's control the costs. Let's get full disclosure of those costs up front, so we're not coming out of left field with this stuff. So that gives us true peace of mind, right? And so how do you control costs in the estate planning world? Number one, I already hinted on it, is full funding. If we get everything in the trust that needs to go into that trust, we're not going through the court system. If I'm not on the court schedule, that saves me time and expense, and that translates into a cost savings for the clients, right? Makes things a lot more efficient if we have a fully funded trust. Most trusts, when I review clients' trust, I ask them, is it fully funded? If they even know what that means, it's typically not, okay? They're usually partially funded, which means we got some of the stuff in there, but those assets that are not in there, guess what? That goes to probate, and then it goes into the trust for the trust administration. You get to pay twice for the attorney on that. Yay. You can do also a way to control the cost is proactive trustee and beneficiary training. Let's make sure your backups know what to do at the right time, right? Rather than try to figure all this stuff out at the wrong time. We find that makes things in. And with the group education programs, rather than doing one-on-one training, hourly billing, why don't we do a group program, right? And keep the cost down and get the education done. Radical approach. And then we have a proactive engagement approach, which says if you're on our maintenance plan when you pass away, then we will agree to administer the plan at predetermined rates, which are lower than the market. I cannot ethically bind your successors to hire us. We can just say we'll do it for you at this price, but they have to affirmatively hire us. They can go to somebody else if they want to. We'll honor our commitment on that. Everyone settles with us, but they have that option if they want to. Some of my clients want me to force them to do it. I can't force them. Just to kind of focus on the funding side, This basically funding means just everything goes into the trust. The one asset that you don't go into the trust, okay, just so you know that I know this, is we don't put your IRAs or 401 yours, the participants' 401ks or IRAs into the trust. Those are contracts. They're going to avoid the probate system by going to the right beneficiary, right? If I put them into your trust, then your IRA or your 401k, the IRS considers that a distribution, and that's when taxes are due. I don't want to do that. I want to minimize your taxes. But with the power, with IRAs, there's a couple of issues. One is, or qualified plans. There's a couple of issues. One is, let's make sure that there's a financial power of attorney that's valid, that will work if you become disabled, so that someone else can manage the distributions, manage those accounts, right? Because if the IRA is not in the trust, right, then the main point, every asset that's in the trust, the trustees manage it. But if it's not in the trust, there's no legal authority. So we need a different legal document that does the same thing as a trust does, but for those assets outside the trust. And that's what a financial power of attorney is primarily used for, okay? The other area for IRA planning for special needs individuals is making sure that the beneficiary is the right type of trust, special needs trust, that satisfies the IRS guidelines as a eligible designated beneficiary, so that the special needs individual can get a stretch out over their life expectancy. There's a lot packed into that, right? And so inherited IRAs are IRAs that are left to non-spouses. And the Secure Act said, hey, for IRAs to left to non-spouses, the old rule was if that beneficiary was 20 years old when they got that inherited IRA, they did not have to take the money out. They would have to take it out over their life expectancy, which could be like 60, 70 years, which means that IRA money can build up over time, and the beneficiary only had to take out a little sliver each time. The Secure Act said, you know what? IRS was like, we need that money sooner, because they don't get to tax that money until the money comes out of the IRA. Forget that life expectancy stuff for non-spouses. 10 years. That money's coming out in 10 years, okay? But there's exceptions, okay? Spouses are exceptions, special needs individuals are exceptions, minors are exceptions. So there's exceptions, and then lawyers that are good, right, know how to deal in exceptions. All right, let's talk about costs, okay? So here's how we set our fees. These are ranges. I can't give you the exact number until we know. What I can tell you is that you're not going to get charged anything until we know exactly the scope of services that are that we're doing, and that your specific situation. Here's the fee. Here we go. And so the issue that you need to understand, there's a cost of the initial counseling in the documents. There's cost of updating or failing to update, and the cost after death. Most people focus on the cost of the initial counseling. They don't even think about that other stuff. A lot of people don't even update. Okay. So here's how we set our fees out there. And this is for our base revocable trust planning. If we need to do a standalone special needs trust, that's an add-on. Typically, that's an add-on to this fee schedule that I'm going to go through with you, depending on their situation, as between 3 to 5K add-on, 3 to 5,000 add-on, depending on that situation, if we're doing a standalone. A standby special needs trust is typically integrated within this type of plan here. And we went through the differences. And again, this is just overall education. All right. So this is how we set it up. Let me give you some explanation on how the administration fees work. So everyone focuses on the fees up front, but let me start with the back end fees so you know how things work. So when someone dies, a lot of people don't know what attorneys are charging. Okay, I'm just using Fairfax County schedules here. Every county in Virginia is the same. Maryland, I'll show you in a separate one. But this is if you have a will, okay? And these are public schedules. You can go to the court and pull these online or offline. And so Virginia, I love how Virginia puts the quotes. Virginia is a reasonable compensation state. So what does reasonable compensation mean for in Virginia? So if you're going through probate, right, you went with the will approach, it's basically off of a percentage schedule, okay? So while the assets are tied up in probate, any income being generated, any rents, dividends, and all that stuff, 5% of the income is a reasonable fee to take, okay? And then if you had $1 million in probate, right, the principal assets are $1 million, then the first 400,000, they could charge 5% on that. The next 300,000, 4%, and the next 300,000, 3%. And this says fiduciary compensation schedule. So a lot of times if there's a married couple, they'll have the spouse be the fiduciary. Spouse has no clue what to do. They hire an attorney. The attorney charges the schedule. Now, do all attorneys charge this? No, some will charge less, some will charge more. This is just the guidelines. I find typically attorneys will charge the most they can on their side. And then here's the phrase on the back side of that schedule. The commissioner may increase, the commissioner of accounts for the county, increase or decrease the allowable compensation in exceptional circumstances. Factors to be considered or determining compensation include the nature of the asset, the character of the work, and the difficulties encountered. So the more out of whack the estate is, the more they can charge, the more things are organized, the better. How do you organize stuff? Get everything titled right and get everything neat in order up front. Loudoun's the same as Fairfax. And then Maryland, if you're a Maryland resident, Maryland is just 3.6%. Anything over 20,000 bucks, the first 20,000 they can charge 9%. Anything over 20,000 they can charge 3.6% to do the administration. Okay. All right. So that's if you did the will. You said, Bobby, well, I like the trust. Let's do the trust approach. How do are there any charges for the trust? Yes. And that's why I put the Florida statutes here. So you may not have any Florida assets. That's not the point of this. The two teaching points with having a Florida statute here is, and let me back up. Would you agree that Florida has a strong kind of senior lobby? Some people call it God's waiting room. So a lot of seniors are there, and there's a lot of trusts that are out there in Florida, and they got tired of what attorneys were charging on the administration. So the first teaching point is, whether you do a will or a trust, death is a major life event. I might be joking, right? Every one of your relationships have to be closed out, okay? So there's work to be done. Doesn't matter if you do the will or trust, it's whether you're going to go through court or not, okay? And I find when you're not going through court, that reduces the cost. So that's number one teaching point is, it's work, and it's going to be your family doing the work at that time, right? And then the second teaching point is that Florida is such a strong consumer protection state for seniors, they put a cap on what an attorney can charge. That kind of gives you an idea of what the market rate is that's out there for administering an estate. And then I'll boil it down. It's just this third paragraph here. Basically, the attorney can charge 75% of what they could have charged on a normal probate. And that's a reasonable fee to charge for a trust administration. And Florida, you're going to see the Florida schedules, which I gave you for the probates, are lower than the Virginia and Maryland schedule because they're such a strong consumer protection state. But it's still a schedule, right? So the first 100 to 900 grand, 3% of that. So you can get a 25% discount on that. Anything between 1 and 3 million, 2.5%. So you get the idea. In Virginia, it was like 5%, 4%, started at 3% here. All right, enough more than you ever probably want to know. Here's how we do it. So we just talked about death. So on the administration, we'll cap under option one, and most people take option one. You can take whatever option you want. Most is that we'll cap the administration fee at 1.25% on the size of the net estate, only if we're hired, and it's only due at the death and when we're hired at that time. You just saw 5%, 4%, 3%, 2%, right? We're going to be lower because of this maintenance plan. So the maintenance plan, I've already told you, is $975 a year. And so if I have a fully funded trust and I'm not going through court, that makes my job easier. That translates into a cost savings. If I have an educated family that knew what to do at the right time, makes my job easier. If I have a financial advisor or a planning partner can set up the inherited trust accounts and the like, makes my job easier. If I have updated legal documents complying with your latest goals and the latest laws, makes my job easier, translates to a cost savings for you all, right? So that's the 975. The 1,500 is to initially fund the trust. That's our funding fee to put everything in the bucket initially. That's the tedious, time-consuming stuff. And one of those questions that is in that initial questionnaire that I would be asking the attorney is, who's responsible for the funding, you or me? Usually they're selling you documents, okay? And this is the time-consuming stuff. We're going to manage that process for you. And that's where the first year, to enroll in our maintenance plan, we charge you a little bit more than the 975 so that we got the funding set up and we know it's done right. After that, you don't have to stay on our maintenance plan. Everyone does. We have like a 99% renewal rate. But I want to make sure when you leave our office that everything is set up right on day one. Okay. The upfront cost of the planning, setting up the trust, setting up your pour over will, your medical directives, your powers of attorneys, okay, and making sure that we've strategized on the funding and everything is in the right place. We charge 1/2 of 1% on the size of your net estate, subject to a minimum fee of $4,000. Our maximum fee is $13,500. Where you land on that depends on your goals, assets, and the like. If that's too high for you, you can do the option 2. Option 2 is 1/3 of 1% on the size of your net estate. The minimum is still 4K. Our maximum there is 10,000. The difference between option 1 and option 2 is that we're going to charge higher on the back end. We're going to charge you 2% to do the administration if we're hired at that time. So pick whichever one you want, option 1, option 2. And so a lot of people ask me a couple questions. I'll just go ahead. I've been had enough people ask me questions that I just take those off the table. They say, Bobby, that sounds great. What if something happens to you? Right? I have more clients worried about my health and welfare than I've ever had in my life. I would not be a good estate planning attorney if I didn't have a good succession plan in place for me. And so I have a backup attorney who teaches with me at the National Network of Estate Planning Attorneys. His name is Ed Clay. His bio is in the initial bios that have been circulated to you. And so he's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his until my internal succession plan is completed. So I've got about 5 more years till my junior associates and interns are going to be in a place where they can be able to take over as a successor if something happens to me. But until I feel comfortable with them, they're going to be at that point. The second question people ask me is the 975, Bobby, will that ever change? And so that number has only changed once in the last 10 years. Probably will be changing about every 5 years. Okay. And so the idea is to keep you going with it. The last fee increase was $50. So you get an idea. I have about 300 families on our maintenance plan. I don't want people showing up on my door saying, what are you doing? Right. I have a very commitment to them. So the idea of the maintenance plan, and it is a loss leader for us because we can provide a lot of value, is really just to break even and maintain the relationship for the administration side of things. Okay. And so I'm just showing you my business model is very clear. I have 3 revenue streams and I'm not making any bones about it. Very full disclosure. I'm not what you call a will mill where I'm trying to get 1,000 plans a year, where I see some of these attorneys are trying to come up with these new, streamlined basis. Our goal is 60. Okay, 60 plans, less clients, more detail work, more preparation, less clients, better relationships. Okay. The maintenance plan reduces stress for the attorneys because we got residuals coming in. We have a very high renewal rate. It's we only had 1 person drop off last year. And now we're getting our existing clients are referring us, which means we're doing something right. Okay. And then everyone's hiring us for the administration, although they don't have to. So it's a very simple business model. Makes a lot of sense, and that shows the successor attorneys that, hey, this is something that's ongoing, and so that's the way that we do it. So I'm very full disclosure on how we do the fee options. Again, we don't pay anything until we know what you're doing, scope, and here's exactly what we're doing. Here it is. If we want to do it, and I'll show you our process chart. So how the things work. I just find process produces predictable results. So our process chart looks like this. You're at step 1, and we're going through our client orientation, our process philosophy, common pitfalls, and the like. If you like what you hear, you'll schedule with Michelle the discovery dialogue, where Wendy Masomer, our associate attorney, will kind of check your vitals, right? She'll review your personal information form. She'll look at your goals. She'll give you a goal setting exercise. She'll answer any questions. She'll ask you questions. And then she'll say, here's the fee ranges that you're looking at. And you're like, yeah, I'm ready to go. We'll have engagement agreements ready to go with specific scope. That's at the initial interview, and the specific fee quote. And here's what we'll do. And if we agree on that, we'll jump into the design. If you need to think about it, that's why I put a little line there. You don't have to do it at that meeting, right? You can think about it and then come back. To me, it's it's an investment. It's important decisions. All your wealth and your family, right? The design meeting is when we'll go through that trip to the eye doctor, right? That's usually 2 to 4 hours. I would never do one meeting in 4 hours. We break it up, right? To me, I'm not nickel and diming. Let's get the instructions right. That's the most important thing to me. Okay, let's do it right. Because if we don't do the instructions right, everything flows from that, right? If we do that wrong, everything else is gonna be wrong. Let's get the instructions right. Then we have a delivery and review meeting. We'll make sure you understand the legal documents, answer any questions that you have, formalize it, witness it, make it legal, okay? But we're not done yet. Then we have a financial strategy meeting, right, where we look at your financial plan and make sure it's coordinated with the estate plan. And then we got to figure out what goes into the various buckets, get everyone to sign off on it, and then we manage the funding. Remember that funding, we have a funding coordinator. We actually have a junior funding coordinator. I don't know many law firms that even have a funding coordinator. That means they're the ones making sure that everything is titled properly. We're going to need your help, but we're going to manage that process, okay? And then there's an optional family meeting, okay? As long as it's done within a year of the plan, there's no additional charge, where we'll go over the plan as high level or as detailed with whoever you want. And then you're on maintenance, okay? The heavy lifting is up front. Then we just do the maintenance. That's the 975 year. Let's just make sure that the documents are updated, educated family and the like. That's it, okay? A lot of people ask me, well, how long does it take as a process? Usually, if you're motivated and you're ready to go, and if you did your discovery dialogue today, 6 to 8 weeks before is when you'd have your legal documents in your hand. The funding takes a little bit longer, but you'll have the legal structure in place. But I don't know when the county is sending me back the recorded deeds or the financial institutions, the verifications. We commit to 120 days. That's usually kind of the timeline from that. But that's why, that just letting you know how the process works on that. All right, so I'm a Paul Harvey fan. I don't know if you know, he was a radio announcer. He always says, what's the rest of the story, right? So I would ask the attorney, what are the rest of the fees besides a setup fee, right? What are you charging me for trust settlement administration, right? And that's what I just showed you. If I died today, what would you charge my family? They say, I can't tell you that. Well, I died today. Here's my list of assets. Tell me what you would charge my family. You're probably not going to like what they have to say on that. Our death tax returns part of that. Death tax returns are a lot more common than they used to be because of this concept called portability. I didn't talk too much about estate taxes. That's definitely will minimize that. The estate tax exemption currently is at $12,060,000. You have to die with more than that amount before a federal estate tax is due. If that is applicable to you, good for you. It's going to go back down to 5 million to 6 million on January 1 of 2026. So you need to make sure that whoever's doing the planning is cognizant of the law change that's going to occur. But there's something called portability where that should be filed to protect coupons and the like. That's part of our administration fee. And my trick question for the attorneys are, if they're a trust attorney, how do you charge for probate services, right? What percentage of your trust-based plans go through probate? So I told you we had that one. Okay, we've done 50 administrations. We had one, and it was one asset, and then they didn't disclose it to us. But if they're going through a lot of probate, that should be a red flag to you. All right. And so the cost after death, the traditional approach, like those Virginia schedules that I was showing you on the wills, the probates are 2.5 to 5%. The standard living trust planning are those Florida schedules that showed you the 25% discount. Ours is 1 to 2 for the life of the plan, but that's just the way it's less, and it actually works. It's one of those things that you maintain. If you maintain it, good things happen. And hopefully you'll see, on the fees, probably more than you ever want to know, but I find full disclosure, hopefully it'll give you true peace of mind. This is what the family should expect, and we've got that. All right, so the last slide is basically comparing what I call the traditional planning approach to the modern approach. The traditional planning approach is like you got some basic documents and questions answered, okay, versus the modern is you get the counseling, the funding, right, the maintenance, the updating, the education, disability events occur, surviving spouse, and settlement. So we're looking at the whole picture, okay? It's a relationship-based approach with your planning attorney. Let me see how I did on those questions I would be asking an attorney, and then I'll conclude. So about an hour and 20 minutes on this one. So I would ask the attorney what their interest, background, and planning, and what percent of their practice is in estate planning. We do estate and business planning. I'd say 60 to 70% is estate planning, 30 to 40% business planning. Where we don't do family law, we don't do personal injury, we're not doing litigation. This is our core competency. I think that's enough. How do you define estate planning? Remember that definition of estate planning. I think it's important, but find out what the attorney feels about it, right? I want to control my property while I'm alive and well, a plan for me and my loved ones if I become disabled mentally, right? Then I want to give what I have to whom I want, when I want, and the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. I like that, right? It's very simple. What is your counseling philosophy? That's that pyramid. We want to get to know you first, the family. You teach us the family, then we'll teach you the law. We'll co-create the plan. What's your process for working with me? I just showed you my process chart. I think it produces very predictable results. We've been doing this for 15 years on this process. I've been an estate planning attorney since 2002. I was a litigator before that. I hated that. How do we assure my assets are controlled by my instructions contained in my planning documents? That's that funding question, right? Who's responsible for this coordination? You or me? Are you going to charge me extra for that? Make sure you know the fees up front. I showed you everything. How do we assure my plan stays current with changes in the law? That's our maintenance plan. What's the level of involvement of my family in the planning process? I find more is better, but every family is different. We just got to figure out the lay of the land. How do you charge for services? Specifically, how much will my estate be charged after I'm gone? What's your record with regard to probate? I already talked to you about that one. What percentage of your trust-based plans wind up having assets probated? Do you charge differently for those assets? Do you handle the filing of the death tax returns? Yes, that's part of our deal. What if something happens to me, right? Happens to you? That's my succession plan. A lot of attorneys don't have their own succession plan. How do I prepare for our consultation? There's a personal information form that you'll get, or if you haven't already gotten it, if you schedule the discovery dialogue, that we want to make sure that we have a complete picture. All right, this is where the assets are, the biographical data and the like. What type of service should I expect from you? I mean, basically, I'm a big believer that it's a team approach. We have different departments. I'm great with accounting. I'm the lead attorney. Ginny is great with the funding and the titling of the assets. Wendy is great with the drafting and the like. And Michelle's great with coordination, scheduling and the like. So everyone's got a team, right? Rather than just one person, everything's bottlenecked with one person. And then any commitments from you, just complete your personal information form, respect our process. We've done this before. You can think about potential helpers, right? These are your backups on money issues or healthcare issues. We'll help you make that decision, but you can come up with some candidates for that. You want to make sure you have an current inventory of your assets. And I think with that, I'm going to conclude. I think that's all we really need to go through for today. If there's any questions, I'd be happy to answer any questions that you have. Otherwise, I will conclude. I will shut this down in about a minute or two. All right. Thank you for your time. I am going to conclude. Have a good day. It's been Bobby Fazy, president of Insight Law. Hopefully we got you some good information with regard to estate planning. Thank you.